my lord.
That comment.
No, with respect, my lord. But they cannot say that we'll give preference to these candidates. That is my submission.
All right, we'll see whatever.
My lord.
Done, we can.
And one last line, my lord. I have gone through the judgment cited by my learned brother. It is clearly saying that if the rule doesn't permit, nothing can be done. Your lordship, I have annexed that rule in my case. In my case, your lordship, rule 20. I am reading it only one line. That is relaxation. Where the government are of the opinion that it is necessary or expedient so to do in the public interest. Page 38, I am reading, my lord. Page 38, the relevant portion of the rule. Where the government are of the opinion that it is necessary or expedient so to do in the public interest, it may by order for reasons to be recorded in writing relax any of the provisions of these rules in respect of any class or category of persons. My lord, my prayer before your lordship, that are the candidates, those who are contesting the matter. My lords have permitted us to appear the examinations and we have appeared examination. We have scored thrice more marks than other candidates. It is not a question that other diploma officer.
This submission you have made for 20-25 times. You are not required to repeat that.
My lord.
And if you want, you can submit, make your written notes of argument. We will see that why.
My lord, my prayer is that your lordship, under Rule 20, at least the petitioners, because in Jahur case also, Honorable Supreme Court said the appellants, only they will be given 2 years relaxation. So others are fence sitters. We are before your lordship. So your lordship may consider our position and may take into account Rule 20 also, that these petitioners at least, they may be, because that the rule permits. And in Jahur case also, your lordships have said that only the appellants will be given 2 years relaxation and no other person will be given. That is this judgment cited by my learned brother. So my prayer is that your lordship, these petitioners for this time only, because 212 posts are there. We are only 15 petitioners. 212 posts they are advertising. Considering the plight of these petitioners, your lordship may kindly even direct under Rule 20 that they may be given equal opportunity this time.
We will never do that.
My lord.
If we do that, we will be doing for everyone, not for these petitioners only. All right. The Supreme Court may pass orders, as has been passed in other cases, but we will not, never. All right. Our orders will not be confined to these petitioners only if such orders violate Articles 14 and 16. All right. So if we we'll allow everyone. Otherwise, we decline. That slip shall be declined to everyone. Yes.
I have already filed a written note of submission.
Yes.
I have already concluded, madam.
You can give your written notes.
I have already filed, madam.
That will help us.
I have already filed.
Item number 63.
My pleasure.
Before my
Affidavit.
Item 63. So I was going for an accommodation. Or in the alternative, if my will accept. I'm saying begin the petition will begin will give a reply.
In fact, honestly speaking, that submission of yours relieves us also. Temporarily, but yes.
Temporarily.
Yes. So what should we do?
But I propose not haphazardly. Today I'll do. Why not your lordship keep it a particular date so that the
farm date be fixed so that all of us
so that all of us can be heard. And this is that matter, lordship, hard. Just a rule was there in 1993. Just for a moment. And in 2003, because of the financial problem, they said that they issued a resolution that all the sanctioned vacant posts to be filled up by way of contractual appointment in secondary schools. They they made the procedure, but these rules, whatever procedure is there, that procedure will be followed, but the appointment will be made on contractual basis. And in 2004-5, these people were appointed. And in 2011, a circular was issued by the government that on completion of 6 years of service, their service will be regularized against those sanctioned posts, and they will be treated as a government employee for all purposes from that date, on the date of completion of 6 years. Then likewise, they gave appointment every year, 2012-13, on the basis of that earlier circular of 2003, and they are also regularized. For the first time in 2013, they made a rule under Article 309, contractual appointment. In supersession of all rules and government circular, appointment will be made henceforward on contractual basis, and a provision was provided that on completion of 6 years, same thing, that they will be deemed to have been regularized in that post. So on the basis of 13 rule, in fact, the appointment was started in 2016. Persons, those are on 13 rule. But in the meantime, those persons, those were appointed in 2012-13, they completed the period of service of on completion of 6 years. Their service were regularized also. But in 2022, they repealed the provision of 2013, wherein they said those persons, those who were appointed under 2013 rule, they will get the benefit of all national benefit and everything with effect on the date of their initial appointment as contractual. Whereas the contractual appointees who have been already regularized way back in 2011 or 2012 after completion of 6 years, they have been excluded. This is the sum and substance. And what they have done, after this rule came into force in 2000, repeal rule came into force in 2022, they
have those who were working already on contractual
on
appointment,
contractual basis.
Would they have applied after 2012, 2013 rule? Whether they were required to apply or not, or whether there was any requirement for them to apply again for contractual appointment?
Not required. That was not also that was not required. The only is, this is why you have to rule under Article 309. They were appointed by virtue of a resolution of executive instruction, despite the rule was in force, 93 rules. Now they have been regularized in 2011. But unfortunate part is that those persons, those who are appointed after 2013 rule came into force in 2016.
Everything, the main issue is as to whether those persons who were appointed prior to 2013,
Right, sir.
whether they were also required to apply under 2013.
No. By that time, they have already regularized. Yes.
Already regularized. So they were not required.
No, not required at all.
Or they were already they were not they were
Yes.
already regularized, therefore.
And more important, after the rule also, the repeal provision was made, they have made a SOP, 2 SOPs. In the SOP, they have now said that Group A, Group B, Group C. Group A, those persons were appointed after 2013 rule came into force. Group B, those persons were appointed prior to 2013, but they have been regularized after 2013. And Group C, we are the persons. Those who have already been regularized by virtue of the executive instruction in 2011. And so far as we are concerned, no benefit at all. But so far as Group A is concerned, all benefit right from the date of appointment. Now, by that process, we are losing 6 years of service.
So has he been able to prejudice our mind?
Sorry.
We've been reading the matter. We are reading the matter. So we say that our stand is 2013 rule stands different. It can't be what my non-senior with respect to what the submissions forward now. That because they were appointed in 2011 after 6 years, they were regularized, and now because of 2013 rules who were appointed, they are regularized.
No, was there any difference between the process of entry based on resolution before 2013 and post 2013?
The biggest difference was under 2013 rules, the persons appointed, they had the knowledge that after 6 years they will be regularized. But all these appointments, they were not given such assurance.
So you could have.
Yes, we have, that's what we are going to place, Guzman.
Or we will see. So we will hear both of you with open mind.
Yes, sir.
That
Your Lordship will fix any date.
Line would be only the benefit of regularization.
after vacation.
That's right. Keep a date so that at 2 o'clock, so that we can be ready.
As jointly requested on behalf of the parties. this matter on, these matters on 10th July,
At 2 p.m.
2 p.m. to be taken up at 2